everyone. Welcome to Crime in Court. This is the Commonwealth versus Karen Reed Trial 2.0, and we are reading the motions in limine, episode 126, exhibits and demonstrations. And motions in limine are motions that both sides can file at the beginning of or right before a trial where you can ask the judge to exclude or include certain evidence, certain testimony, certain whatever. So we have been bombarded with motions in limine this week, early this week from the Karen Reed defense team, and I'm working my way through them slowly but surely. And here we go. So let's get started. We're going to talk about, like I said, exhibits and demonstrations. These are some of the visual aids that we might be seeing at trial. Please hit that like button if you haven't already. And let's get started. All right, so up first is the Commonwealth's motion in limine to allow expert Cellebrite demonstration. So, did they do this in the first trial? I'm totally blanking on this. I want to say that they were told that they couldn't. I cannot remember. Anyways, the Commonwealth provides notice that it intends to call digital forensic examiners Jessica Hyde and Ian Whiffen. If you remember, they both testified. I've talked about them at length on this channel because they claim that the house long to die in cold that search did not happen at 2:27 a.m. and it only happened at the 6:23 and 6:24 a.m. times when, as most of you following my channel know, that how long to die in cold search actually did happen at 2:27, and the 6:23 and 6:24 searches were to cover her tracks. But anywho, Jessica Hyde and Ian Whiffen, for some reason, either didn't have all the information or for some reason interpret it a lot differently. So they don't see it the way that Richard Green, Karen Reed's data forensic expert, does. So the Commonwealth respectfully requests. So they're going to call Jessica and Ian again. The Commonwealth respectfully requests that during Mr. Whiffen's expert testimony, I tried to somehow I went Ian and Whiffen in one. Sorry. Okay. The Commonwealth respectfully requests that during Mr. Whiffen's expert testimony, the court allow him to conduct a courtroom demonstration of how data was stored within Jennifer McCabe's cell phone. Mr. Whiffen is the senior digital intelligence expert for Cellebrite. Cellebrite is the leading forensic data extraction software. I don't know if that is the case for sure, but it definitely is one of the leading ones, and it is used nationwide by feds, state, uh, law enforcement for um, extracting cell phone information. He's saying that Cellebrite is the leading forensic data extraction software tool that provides examiners the ability to access and analyze data stored within a digital device. The Cellebrite software allows an examiner to parse the layers of data through different methods of extraction and analysis. Also, Jessica Hyde will use a courtroom demonstration to show jurors information and data on both Jennifer McCabe's and John O'Keefe's phones to explain concepts and to illustrate particular information of importance about each respective phone's data. Jennifer McCabe provided her cell phone to law enforcement in the days following John O'Keefe's death. After she deleted a bunch of stuff, messages between her and her daughter, and as we know, her daughter was Colin's getaway driver. So she deleted messages between her and her daughter from that night, and law enforcement let her do that before she turned her phone over. Jennifer McCabe provided her cell phone to law enforcement In the days following John O'Keefe's death, Cellebrite software was used by the Commonwealth and the defendant's expert to interpret the digital data. Cellebrite extraction reports are computer generated records and do not implicate the rules against hearsay. In Mr. Whiffin's expert reports provided to the defendant in 2023 and 2024, Mr. Whiffin utilized his superior knowledge of Cellebrite software to demonstrate how. Okay, so he did. In no, those were in his reports. Sorry. So he didn't demonstrate. Sorry, let me read that sentence again. In Mr. Whiffin's expert reports provided to the defendant in 2023 and 2024, Mr. Whiffin utilized his superior knowledge of Cellebrite software to demonstrate how, where, and when Jennifer McCabe's Google searches were stored within the digital databases. The Commonwealth moves to permit Mr. Whiffin to conduct a demonstration using Cellebrite software to enable the jury to better understand the digital forensics. It is within the sound discretion of the trial judge to permit a courtroom experiment, demonstration, or reenactment. Permitting demonstration of what could be seen through a telescope under different conditions by allowing jury to look through the telescope that was set up in the courtroom. Trial judges afforded what crimes are being committed through telescope? Anyone? Okay. In assessing whether a demonstration should be admitted as evidence, the key question is whether it sufficiently resembles the actual event so as to be fair and informative. It is within the trial judge's discretion to admit a demonstration or a reenactment when it would further the jury's truth-seeking role. The Commonwealth intends to have Mr. Whiffin use the highly disputed extraction report from Jennifer McCabe's cell phone to demonstrate with Cellebrite software how, where, and when the digital data of the Google searches were stored. This demonstration would closely mirror the actual Google searches conducted by Jennifer McCabe on January 29th, 2022, and would aid the jury in understanding how Mr. Whiffin is able to opine that the contested searches occurred at the approximately 6:24 and not the 6:27. So if you recall, she spelled it completely differently in her 623 search. So she had to cover it again and spell it to her first misspelling, the one that she did at 227 to make up for it. So she searched other things in that time on that tab. I don't understand why now we're saying that it was 624, but cool. Okay. Lay witness testimony that a blank article of clothing could appear light colored when viewed at night using the type of surveillance system at issue was appropriate given the judge's understandable concern that without the jury hearing such testimony, they might well have applied a skewed view of the strength of the exculpatory value of the surveillance video. Notably, the defendant does not dispute the reliability of the Cellebrite software, and her own expert has relied on Cellebrite to draw their conclusions. Experts' experiments about drying time of paint were not sufficiently reliable in a homicide case as there were no scientific or technical basis for opinion and lacked a sufficiently reliable methodology. In addition, both Mr. Whiffin and Ms. Hyde would use demonstrations to articulate and explain important data information contained on both Jennifer McCabe's and John O'Keefe's phones. The proponent may use a summary chart or the like to prove the content of voluminous writings or records that contain or that cannot, sorry, I can't read today. I've already been reading for a while, so here. Um, my brain's just probably fried. The proponent may use a summary chart, or the like to prove the content of voluminous writings or records that cannot be conveniently examined in court. Parties should consider authenticating and admitting excerpts when digital evidence is voluminous, and jury may find it difficult to master the technology to find and view relevant portions of evidence. The use of a Cellebrite demonstration by the expert, who is the senior digital examiner for Cellebrite, would serve the essential truth-seeking function of the jury, and the demonstration would be relatively short, concise, and without unnecessary technical language as to not confuse the jury. And that's signed by the prosecution team. What do you guys think? Will Judge Canoni let them do a presentation? I think so. I think she will. I don't think that unless they can prove like his methodology or something is wrong, I don't think they're going to object the uh, defense. But they might want to do their own demonstration or have Richard Green have some kind of his own visual aid to kind of back that up. Excuse me. All right, the next one is the Commonwealth's motion in limine requesting use of chalks and directing both parties to provide visual presentations in chalks prior to using. So a chalk is basically like a big old poster board that is used in court as a visual aid. So now comes the Commonwealth and respectfully requests the court allow the Commonwealth to utilize computer assisted technology to display exhibits and diagrams. Oh, okay. So chalks, I guess, are just visual aids. I don't know. To utilize computer assisted technology to display exhibits and diagrams as chalks or demonstrative evidence. Is that the term? Is that really what it means? I've always thought it was like the big old poster boards, but what is a chalk in legal terms? I'm going to ask. Sorry, I'm going to pause so you guys don't have to sit here and wait for me. Oh, okay. So chalks are anything that they use. So it refers to a demonstrative exhibit like drawings, sketches, or models used to illustrate witness testimony, but it's not considered evidence necessarily. So not in an ordinary sense. So I guess it's um, any kind of visual aid, I'm assuming, because they're talking about using the computer to display their exhibits. So I don't know. All right. Anyways, so the proponent may use a summary chart or the like to prove the content of voluminous writings or records that cannot be conveniently examined in court. Specifically, the Commonwealth seeks to use the following: surveillance videos, photographs, videos from the crash reconstruction, videos from the crash reconstruction. What? Or are you talking about Trooper Joseph Paul driving the car backwards? Is that the crash reconstruction? Or did they actually get some crash reconstructionist? I think they actually got crash reconstructionist for Trial 2.0. So they have videos from the reconstruction at One Meadows Ave. They did a reconstruction there, diagrams of scene and roadway, and diagrams and digital forensic extraction reports to be projected onto a screen or computer. Enlarged photographs are clearly admissible if they are sufficiently verified and are fair representations of the subject matter, and the jury and aid the jury in understanding the issues. So then why the heck couldn't Alan Jackson bring in photographs of um, Katie McLaughlin? If it, I think it meets the standard. They could have verified them. They had a fair representation of subject matter, and um, it would have helped the jury understand that she was a lying liar who lies. I think. All right. A trial judge has considerable discretion regarding the admission of chalks. Commonwealth versus Walter. The Commonwealth asserts that the technology will be used to merely display admissible evidence or to assist the jury in understanding certain testimony. Parties should explore the viability of admitting excerpts of voluminous video recordings pursuant to mass general evidence statutes, particularly where a jury may find it difficult to master the technology necessary to find and view the relevant parts of the complete video in the jury room. No abuse of discretion in admitting compilation of surveillance video. So you can admit a compilation of bunch of videos, I guess. It's cool, according to the. Why do I only have 2 pages? Oh, that's it. It's signed respectfully here. It just cuts off. Further, the Commonwealth requests that both parties provide advance notice of any visual aids. So if the defense is using visual aids or chalks or anything, let us know. We want to know. They want to know before, if you're going to use them during trial, or before, or during. I cannot talk today. During opening statements or closing arguments. You cannot. They just want to know what visual aids the defense might use. I hope they have a dog bite expert with like some pictures, or not pictures of like dog bites, but some kind of diagram or something, like to know how the patterns to recognize for an animal attack versus, some sharp tail light, whatever. All right, so let's move on. Defendant's motion in limine to present demonstrative exhibit based on Christina Hanley's testimony. So, who is Christina Hanley? I don't know. Must be a witness on the prosecution's witness list. So now comes the defendant, Karen Reed, and respectfully moves this honorable court in limine to present the attached demonstrative exhibit or chalk to the jury. This chalk is necessary to clarify critical evidence and will aid the jury in understanding the testimony presented. Ms. Reed is accused of the following crimes arising out of the death of Officer John O'Keefe: homicide in the second degree in violation of the Massachusetts statutes, manslaughter under the influence of alcohol, and leaving the scene of personal injury and or death. On January 29th, 2022, Mr. O'Keefe is captured on video surveillance footage leaving Waterfall Bar and Grill with a cocktail glass from the bar in his hand. The Commonwealth claims that this glass remained in Mr. O'Keefe's possession at the time that he arrived at 34 Fairview Road and was broken in the early morning of January 29th, 2022, outside the Albert residence after being struck by the taillight of Ms. Reed's vehicle. Over the course of several searches, law enforcement recovered numerous pieces of glass from the yard outside of 34 Fairview Road and the rear bumper of Ms. Reed's vehicle. The source, they've got that italicized, so that's a key word. The source of the glass recovered from the bumper of Ms. Reed's vehicle, and the lawn of 34 Fairview Road is material and relevant to this case. At the first trial, Christina Hanley, a forensic scientist of the, that's right, she did testify at the first trial, I forgot. A forensic scientist at the Massachusetts State Police Crime Lab, testified for the Commonwealth about the pieces of glass recovered from the crime scene and from the bumper of Ms. Reed's vehicle. This testimony lasted more than an hour and spanned 37 pages of the trial transcript. Throughout her extensive testimony, Ms. Hanley discussed 16 distinct pieces of glass recovered from 34 Fairview Road and the bumper of Ms. Reed's vehicle. These 16 pieces of glass originated from 4 separate sources. This was not highlighted nearly enough in the first trial. So I'm glad that they are bringing more attention to this in the second trial and have some demonstrative aids. 4 separate sources. So the 16 pieces of glass that they found on the bumper on at the scene come from 4 separate sources. Are you kidding me? How This is the worst investigation, I think, in the history of investigations. So some pieces of glass came from the same source, meaning that they were originally a part of the same object. So some pieces came from obviously, like 4 and 4 could have all been from like 4 different glasses or whatnot. So, anyways, Ms. Hanley Miss Hanley's testimony is very intricate and difficult to follow without some sort of visual aid. During trial, Ms. Hanley herself frequently needed to refer to her notes and request that counsel repeat questions to keep the various pieces of evidence that she was discussing clear. To remedy this problem, the defense proposes to use the use of a demonstrative aid consisting of one chart spanning one page containing representations of all recovered pieces of glass. This is genius. And graphics depicting which pieces came from which source of glass. The proposed chalk tracks directly with Ms. Hanley's testimony and report. The chalk starts by identifying 4 basic categories based on where the pieces were recovered from and who they were brought in by. Each group of the pieces is called an item. So these items are number 1, which is items 3 and 2. I don't know what that means. Item 1 or item 3 2 1. Yeah, that's the name of it. Item 3 2, the base of the cup. Sorry. Okay. So this is the first item. Item numbered 3-2 is the base of the cup recovered from the scene. Item 3-3 is 5 pieces of glass taken from the bumper of Ms. Reed's car, viewed by the laboratory as one item. The next item is numbered 7-12, 9 pieces of glass taken from the scene by Trooper Buchanan, viewed by the laboratory as one item. And the final item, right? Oh no, there's more. No, that's it. That's the final item. 7-14, a single piece of glass taken from the scene by Trooper Proctor. So one single piece of glass, which doesn't fit any of the other glass. We got the base of the cup recovered. We got 5 pieces of glass on the bumper of Ms. Reed's car that are all from one glass, but it's different than the base of the cup back at the scene. And then there's 9 more pieces of glass taken from the scene by Trooper Buchanan, and then 1 more piece of glass taken by Trooper Proctor. And those also belong to separate glasses. Oh, tell me how any of that made any sense. How they would have all of those pieces where and the none of them match. So each smaller piece of glass within items 3-3 and 7-12 has an additional lettered label referencing the additional piece itself within the broader item. Item 3-3 contains the sub-labels A, B, C, D, and E, each letter representing an individual piece of glass. These sub-labels are the same as those assigned by Ms. Hanley in her testimony and in her lab report. Similarly, the 9 pieces of glass in items 7-12 are labeled A, B, C, D, E, F, then I, K, L, skipping G and H, as was done in Ms. Hanley's testimony and in her report. Well, that is confusing, and I sure do hope that the visual aid, like just describing it is confusing, so seeing the actual visual aid would probably help because you understood. I mean, I understood what they were saying, but it sounds quite complicated. For each piece of glass, the chart includes a graphic next to the corresponding label based on which other pieces of glass that piece matched. So the graphics in the columns next to each label correspond directly with Ms. Hanley's testimony, particularly the testimony on pages 75 to 76 and 90 to 92 of the June 5th, 2024 trial transcript. Each sublabel has a graphic next to it indicating which other pieces of glass it matches. Through these graphics, the chalk summarizes Ms. Hanley's conclusions in a simple chart, which Ms. Hanley confirmed was an accurate representation of her testimony. So they've already confirmed with her that it is accurate the way that they portrayed it. To assist the jury in visualizing Ms. Hanley's granular and essential testimony, the defense proposes the attached demonstrative exhibit or chalk to aid the jury, which is attached hereto as Exhibit A. The demonstrative exhibit is something presented to the jury to help them better follow and understand the evidence, but not evidence itself. Demonstrative exhibits can take many forms, including live demonstrations, charts, and even literal chalk figures on a blackboard. Demonstratives are particularly useful where a party presents complicated testimony that may be difficult for a jury to understand or visualize. Why aren't they doing this for the taillight, though? Maybe they do have something for the taillight. I don't know. I would rather have it on the taillight than the glasses, but but I am glad that they're doing this because, like I said, this was never fully represented, never really dug into, and I think that that was, something that now they can look into that a little bit more because they didn't put like it came out in testimony, but they never really pushed back on the fact that it was four glasses, especially to law enforcement. Like, well, where'd the four glasses come from? All right, I don't know where I left off. Demonstratives are particularly useful when a party presents complicated testimony that may be difficult for the jury to understand or visualize. Allowing the use of a 34-page bar chart as a chalk to depict hours defendant billed to Medicaid for a particular period. These sorts of aids are appropriate where 1, they are relevant, 2, they are not more prejudicial than probative, and 3, they sufficiently resemble the actual event so as to be fair and informative, or they are fair representations of the facts the chalk aims to clarify. So I think that qualifies. Finally, the court has broad discretion in determining whether to admit a demonstrative aid. The proposed chalk is highly relevant. Ms. Hanley's testimony is clearly relevant. Whether any of the glass on the bumper matches the cocktail glass at the scene or is from different unidentified source and goes directly to whether the evidence in this case supports that Ms. Reed struck John O'Keefe or the cocktail glass in question. The relationships between the other pieces of glass are critical to understand the scene. Therefore, the chalk, which summarizes Ms. Hanley's testimony about this glass, is also highly relevant, especially given that the chalk provides much needed clarity to an otherwise complicated issue. Without a chalk, the jury would need to be able to either accurately record or memorize the source of each piece of glass and each piece's relationship to all the other pieces in order to make sense of Ms. Hanley's testimony. The complexity of this testimony is underscored by Ms. Hanley's frequent references to her notes and requests for counsel to repeat questions, particularly questions about the relationships between those pieces of glass. Of course, referencing notes and requesting the repetition of questions is permissible and even preferable to ensure that testimony is accurate. However, if a lab expert has trouble keeping track of the labels of the evidence that she analyzed herself, surely the jury would have even more trouble making sense of this critical evidence, making the chalk not only relevant but essential. So that's a good argument. If the expert can't even keep it straight, how do you expect the jury to? The chalk would not prejudice the Commonwealth. Any prejudice that may be argued to stem from the chalk is far outweighed from its probative value. This chalk does not prejudice the Commonwealth in any way. Rather, the proposed chalk would be highly probative in relation to Ms. Hanley's testimony, which would otherwise require jurors to memorize and differentiate the titles and sources of various pieces of glass, and labels that closely resemble one another. It is merely a depiction of which glass pieces match others and a visual representation of Ms. Hanley's live testimony. Given that the chalk corresponds so closely with Ms. Hanley's testimony, a witness for the Commonwealth, it is difficult to see how the chalk could be remotely prejudicial because it's helping Ms. Hanley's testimony. How is this prejudicing her? They're making the chalk for a Commonwealth witness. It's not even their witness, and they're making the chalk. So you can't even argue and say no, you can't use it. Like, what's the Commonwealth going to say? No, you'll give the jury too much information now. Probably they don't want they don't want the jury to have information. So even if the court finds that there is some prejudicial tendency to the proposed chalk, it is far weighed by probative value. The Supreme Judicial Court of Massachusetts has been liberal in allowing demonstrations and chalks even where there is potential for extreme prejudice. In Commonwealth versus McGee, where the defendant was accused of taking the life of his partner in front of their 6-year-old child, youch, the Supreme Judicial Court of Massachusetts upheld the allowance of a physical demonstration by that child, then 10 years old, of the position in which he saw his mother on the couch when her life was taken. That's horrific. Uh, but he's the only one. He's the only witness to be able to make that statement in court. So that's awful that he has to testify to that, but he's the only one that can. So, in support of this decision, the court highlighted the testimony about the decedent's position on the couch at the time of her homicide was crucial in determining whether the premeditation element of homicide in the first degree was met. Given that a live demonstration by a child of the position that his mother was in when her life was taken was permitted as more probative than prejudicial, this proposed chalk, which simply depicts Ms. Hanley's testimony, is certainly more probative than prejudicial, if prejudicial even at all, because we're helping your side make a clearer testimony. So it's not even for us necessarily. The proposed chalk directly mirrors Ms. Hanley's testimony fairly and accurately. As described in detail above, and as seen in the chalk itself, the chalk is merely a summary of Ms. Hanley's testimony. The 4 categories displayed in the chalk, the labels used in the chalk, and the connections between each piece of glass are all drawn directly from Ms. Hanley's testimony. In fact, during the first trial, Ms. Hanley was shown this exact chalk, which was confirmed on the record was an accurate reflection of her testimony. Without the chalk, so did they not allow it in the first one? I don't remember. Without the chalk, Ms. Hanley's testimony will be exceptionally difficult for the jury to follow, which would seriously detract from the important evidence that Ms. Hanley will present. Given the great relevance of the contents of this chalk, its lack of prejudicial tendency, and the tight relationship between the chalk and Ms. Hanley's testimony, the proposed chalk should be permitted. For the above reasons, Ms. Reed respectfully requests that this honorable court allow the attached chalk to be presented. We do not have it. Unfortunately, we will see it at trial if she allows it. All right, this is the final filing that we're going to read through, and it's a short one, so we're almost done here. All right, so now comes the defendant, Karen Reed, and respectfully moves this honorable court, pursuant to the Mass General Laws statutes, to order that the jury be taken on a view of the alleged crime scene. So this is their motion in limine for a view. They want, as they did last time, they want to take the jury there to the scene, to 34 Fairview Road. And last time she let them. So we shall see if she allows it again. This is the power to inform itself by a view is inherent in a court at common law. Ms. Reed respectfully, wow, that's not even what that says. Ms. Reed specifically requests, I like jumbled the two words in my brain for some reason. Ms. Reed specifically requests that the court order a view of 1, 34 Fairview Road in Canton, Massachusetts, and 2, the exterior of 2021 Lexus LX SUV, her car. And Ms. Reed further requests that the vehicle be towed to the public roadway in front of 34 Fairview Road, Canton, Massachusetts. Finally, Ms. Reed requests that this honorable court permit Ms. Reed to attend the view, subject to any reasonable restrictions the court seems necessary. She did not let Ms. Reed attend last time, so we'll see if she does. I remember she specifically said Karen can't go because it was like too much of a circus. She didn't want it to be a circus, whatever that meant. Like I can't remember exactly her words, but she didn't want it to draw too much attention to the scene, and she didn't want her there. There may have even still been a stay away order for her to stay away from the property at that point. I can't remember now at that point, but anyways, she was not able to come. I do remember that. So, according to the statute, it provides that the court may order a view of the jury impaneled to try a criminal case. Ms. Reed states that permitting the jury to view the crime scene located at 34 Fairview Road and the vehicle at issue, the alleged homicide weapon, would assist the jurors in reaching a verdict. Allowing the impaneled jury to view the crime scene located at 34 Fairview Road will be particularly useful because the lawn appears to be much more expansive in photographs than it does in person. In addition, allowing jurors to visually inspect the vehicle will assist the jurors in assessing whether Mr. O'Keefe's injuries are consistent with having been struck by any portion of the vehicle. The chief purpose of a view is to enable the jury to understand better the testimony which has or may be introduced. If you remember Ronnie from his on camera interview with Turtle Boy, I believe he said that doing the jury view was it was good that they did it, but he wished it would have been later in the proceedings because it was early on and you didn't have the full concept of what the heck was going on. You didn't meet the Alberts at that point yet or any of the law enforcement. I think they were still on like the EMTs that week or something. So they really, they were really early on in the case when they did their view. And I think they missed a lot of context by not having a lot already presented to them in order to grasp what this case is about. Because if you are coming in blind and don't know anything and you're going to the scene, you don't know what you're looking for. But if you have some kind of inkling of, well, you know, there might be some kind of cover up and it might be a lie and the first responder that lives in the house didn't come out and here's where it happened and why. Yeah, like you start questioning things when you know more about the case, whereas when you're there you're just like, I don't know what the heck I'm looking for. And Ronnie kind of said that as in as many words, like it would have been better to do later on. So hopefully they do. Continuing on. Although what is seen on the view may be used by the jury in reaching their verdict, in a strict and narrow sense, a view may be thought not to be evidence. Properly speaking, no evidence should be taken or testimonial comments made during the taking of a view. So you're not supposed to talk. During the view, the essential features of the crime scene may be pointed out by counsel, it being permissible merely to point out to the jury marks, matters, and things, but not otherwise to speak to the jury. As with the decision whether to hold a view, the decision to allow a defendant to be present is within the trial judge's discretion. Ms. Reed respectfully requests that the court allow her to be present for the view, subject to any reasonable restrictions the court deems necessary. And here we have a footnote that I missed talking about this other case, Descalakis, was abrogated on other grounds by the Commonwealth, specifically with respect to the doctrine of resurrection in the context of the motion for a new trial. No idea what that other case is about. All right, but they gave us some info. And then for these above reasons, Ms. Reed respectfully requests that this honorable court allow this motion for review. So that is pretty much the exhibits, the demonstrations that we're going to see. We're likely going to see a jury view of 34 Fairview Road and the Lexus again. We are likely going to see some new demonstration, or maybe it's not new, but it's a chalk that's going to help Ms. Hanley's testimony because her testimony might be very confusing regarding the pieces of glass that were recovered both on Karen Reed's car and at 34 Fairview Road. Then, of course, we have Hank and company requesting to use all sorts of computerized chalks and things. Like he's just asking permission. Can we use a computer? Can we use visual aids? We'll share visual aids, blah blah blah. So it's kind of like a general filing that you have to do if you want your visual aids displayed on the computer. And then finally, maybe we will see some kind of a demonstration from Jessica Hyde and Ian Whiffen regarding the Cellebrite data that they were looking at when they made their determination that the House Long to Die in Cold search didn't happen. When we all know that it just doesn't make any sense. How does it not happen? How can data like predict the future if it's telling you this tab was opened or this tab that someone's going to search this at whatever time, but it's timestamped at 2:27. Like it doesn't compute. And Cellbrite, why would that be wrong? When Cellbrite is hardly ever contested. I mean, it might be contested, but I mean, people recognize it as being accurate for the most part, and I mean, it can recover deleted things, but it can't always recover everything. But for the most part, what it does recover is going to be accurate. It's not going to give you false timestamps. So it just, yeah, I'm going to need some experts on Karen's side to back that up. So hopefully she has them lined up. What do you guys think? Do you think, so she has like 12 expert witnesses. Who do you think her expert witnesses are going to be? Besides Arca, we've got Dr. Russell. I feel like I'm missing somebody else. But she doesn't have like the ones that we know of. She doesn't have a ton of experts from the first trial. So who do you think she might have added to this trial? Let me know in the comments below, and I will see you guys in the next one. Take care. Bye now.